A woman in Toronto, a driver in London, a worker in Sudbury. Three different people, three different tickets, three different courtrooms, all three convicted without ever standing up, without ever opening their mouth. And then all three convictions were thrown out. Not because somebody hired a brilliant lawyer, not because new evidence appeared, because the paperwork was wrong. I'm narrating episode 001 of You Defend You, Frank Alfano's plain English breakdown of how Ontario's Provincial Offences Act actually works. This episode is called Laying the Charges, and here's why it matters before anything else. Everything in your case, your forms, your deadlines, your penalties, the defenses available to you, whether you can even be in front of a justice of the peace, all of it is decided by the charging document in the stream you're on. Get the stream wrong, and the rest of the case is fighting from a hole that was dug before you ever walked into the building. That's what we're covering today. The two streams, the consent that locks the gate between them, the conviction standard the Crown has to meet, 8 Ontario cases where courts quash charges over what looks like paperwork, and a practical checklist you can hold up against your own ticket tonight. One disclaimer up front, this is legal education, not legal advice. Every case turns on its own facts. If you need advice about your situation, talk to a licensed legal professional in your jurisdiction. Nothing said here creates a professional relationship. All right, let's lay the foundation. The Provincial Offences Act, RSO 1990, Chapter P33, is Ontario's procedural code for prosecuting offences under provincial statutes. Highway Traffic Act tickets, Compulsory Automobile Insurance Act charges, Trespass to Property Act violations, municipal bylaws, Liquor License Act matters, workplace safety prosecutions. If the offense is provincial, not federal, not criminal code, and the prosecution is happening in Ontario, the POA is the playbook the Crown is using. First thing to understand, this is not the criminal code. A POA conviction does not create a criminal record. That sounds reassuring, and people get reassured by it constantly. They shouldn't. A POA conviction can still take your driver's license, triple your insurance, cost you a job that needed a clean driving record, hit you with fines that run into thousands. In some cases, under Part 3, which we'll get to, jail time. So the consequences are real. The relief is the procedural code. The Provincial Offences Act lays out how charges get started, how you get to court, how trials run, how sentencing works, and how appeals proceed. The offense-creating statute, like Highway Traffic Act Section 130, careless driving, defines what the offense is. The POA defines how it moves through the system. Today's episode focuses on the very first move in that procedural chain, how a charge gets laid. Because Ontario gives the Crown 2 ways to do it, and which one they pick changes everything that follows. The POA runs on 2 tracks, Part 2 and Part 3. Before you argue the merits of your case, before you challenge the evidence, before you even start thinking about a defense, you need to know which track you're on. The stream determines the forms used against you, the filing deadline the Crown had to meet, the penalty exposure you're facing, and the procedural protections available to you. Get it wrong, and everything downstream suffers. Let's walk it. Part 1 starts with a certificate of offense and an offense notice, or a summons. Officer fills out a form, files it with the court, hands you a notice. Section 3 of the POA. Part 3 is more formal, and information is sworn before a justice of the peace. Section 21. That's a real, on-the-record, signed under oath document. Part 1 is the assembly line. Speeding, stop signs, parking, bylaws, things with set fines under about $1,000. Part 3 is for the heavier stuff. Workplace safety prosecutions, environmental matters, major HTA offenses without a set fine. Anything where the Crown wants the option of imprisonment, that requires Part 3. That penalty difference matters. Part 1 is capped. Part 3 is open-ended, whatever the offense-creating statute permits. Some statutes go well past $5,000 and into custodial sentences. Filing deadlines. Part 1, 30 days from the offense to file the certificate with the court. Section 3, subsection 3. Courts can extend that, but you have to check. Late filing without extension is a problem the Crown owns. Part 3, 6 months from the date of the offense to lay the information. Section 76. Some statutes set their own limitation periods. The Compulsory Automobile Insurance Act, for example, gives 3 years. Always confirm against the specific act. Part 1 gives you options without ever stepping into a courtroom. Pay the set fine, request an early resolution meeting, or give notice of intention to appear and have a trial. Part 3 has no out-of-court resolution. You appear, or a warrant issues for your arrest. There is no just mail and a check exit. Forms matter, and not in a paperwork shuffling way. The forms are part of the jurisdictional architecture of the case. Get the form wrong, and the proceeding can fail. We'll come back to that in a few minutes. And the last row, relay. That is the single most quietly powerful provision in this entire statute. Once a charge has been served under Part 1, the Crown cannot simply switch you over to Part 3. They need the consent of the Attorney General, or someone the AG has properly delegated that authority to. Section 21, subsection 2. That consent requirement has teeth, and courts enforce it. Hold on to that. Part 1 is the express lane, high volume, set fines, streamlined process. Part 3 is the formal track, closer in procedure to a criminal proceeding. The critical rule: once a charge has been served under Part 1, the Crown cannot switch to Part 3 without the consent of the Attorney General or their properly authorized agent. We're going to come back to that consent rule and show you exactly what happens when prosecutors get it wrong. Spoiler: the charge dies. Before we walk through any cases, you need to know the sections that hold this thing together. 7 of them. Memorize the numbers. They're going to come up over and over. Section 3, commencement under Part 1. 3 subsections matter. 3. A Part 1 proceeding is commenced by filing a certificate of offense. That word, mapper, commenced, is doing real work. The proceeding doesn't exist until that certificate is filed. 3. The officer completes the certificate, serves the offense notice or summons on the defendant, and files the certificate with the court. 3. The certificate shall be filed within 30 days after the offense was committed or the notice or summons was served. Courts may extend this, but check carefully. Every case, every time. Sections 5 through 8, your options as a defendant. Sections 5 and 6, pay the set fine out of court within the specified time. Some people call this pleading guilty by mail. It is exactly that. The conviction is registered. Section 7, give notice of intention to appear and have a trial. You're saying, I dispute this. I want my day. Set a date. Section 8, do nothing within the prescribed time. Don't pay. Don't dispute. Don't show up. Section 8 is dangerous because Section 8 hands you over to Section 9. Sections 9 and 9.1 are how the system convicts you when you don't show up. Under 9, 15 plus days after service with no response, you're deemed not to dispute the charge. The certificate goes to a justice. The justice examines it. If the certificate is complete and regular on its face, conviction is entered and the set fine is imposed. Section 9.1 catches the next slice. You filed your notice of intention to appear. You said you wanted a trial, and then you failed to show. Same standard, same review, same outcome. That phrase, complete and regular on its face, we are going to spend serious time on, because that is the standard the Crown has to meet. And when they don't, the JP doesn't get a choice. The JP shall quash. Section 21, commencement under Part 3. 21. A proceeding under Part 3 is commenced by laying an information before a justice. The information has to be sworn. It is the formal charging document. And then, 21, the gatekeeper, where a summons or offense notice has been served under Part 1 on, no proceeding shall be commenced under subsection in respect of the same offense, except with the consent of the Attorney General or his or her agent. Read that twice. Sit with it. If Part 1 started, meaning a notice or summons was served, the Crown cannot just switch you over to Part 3. They need the consent of the Attorney General or an agent who has been properly delegated that specific authority. This is the gate, and we're going to show you what happens when prosecutors try to walk through it without the key. Section 25, the curative provision for Part 3 informations. It says, and I'm summarizing, no count in an information is insufficient by reason that it does not state certain required elements. Sounds powerful. It isn't in the place that matters most. Courts have held that 25 cannot cure a fundamental nullity arising from the total absence of consent under Section 21. In plain terms, if the consent wasn't there in the first place, Section 25 doesn't bring it back to life. Section 25 cures defects in the form of an information that the court has jurisdiction to hear. It does not supply jurisdiction that never existed. Section 36 is the Part 1 parallel. An objection to a certificate for a defect apparent on its face shall be taken by motion to quash, and the court shall not quash unless amendment would fail the ends of justice. Some defects are too fundamental for Section 36 to cure. But here is the part the Crown does not want you to notice, and this is critical, so listen carefully. Section 36 applies at trial only. It does not apply in Section 9 or 9.1 default proceedings. We will come back to that distinction. It is the difference between a case the Crown can salvage and a case that dies on a clerk's desk before anyone shows up. Section 76, limitation periods. 76. A proceeding shall not be commenced after the expiration of any limitation period prescribed by or under any act, or, where no limitation period is prescribed, 6 months after the date the offense was or is alleged to have been committed. That 6-month default backs Part 3. Part 1 has the 30-day filing requirement we already covered, and some statutes set their own. The Compulsory Automobile Insurance Act gives 3 years. The Securities Act gives 6. Always check the specific statute creating the offense. The POA limitation is the default, not a ceiling. Those are the 7 sections. Section 3, 5 through 8, 9 and 9.1, 21, 25H, 36, 76. Now let's talk about the standard the Crown actually has to meet. Here is the thing most people facing a Part 1 charge never realize. You can be convicted without ever appearing in court. That is the default conviction mechanism. Sections 9 and 9.1 of the POA. Set up exactly so the assembly line can keep moving when defendants don't respond. Hundreds of thousands of charges run through it every year. But that mechanism, the one that lets the Crown convict you in your absence, in chambers, on paper, operates under strict compliance rules. And when those rules aren't followed, real defense opportunities open up. The standard is unambiguous. The certificate must be complete and regular on its face. Anything less, and the justice is required to quash. Not permitted to quash, required. This is the justice's binary choice. There is no middle ground. If the certificate is complete and regular on its face, the justice shall enter conviction and impose the set fine. Section 9. If the certificate is not complete and regular on its face, the justice shall quash the proceeding. Section 9. That's the entire universe of options. There is no third box that says, justice may amend, fix, save, or salvage. That box does not exist in default proceedings. This is the part the Crown will try very hard to avoid in front of you. A justice acting under Section 9 or 9.1 has no power to amend the certificate. None. Now, there are amendment provisions in the POA, Sections 34 and 36, but those provisions apply at the trial stage only. And Rule 15 of O Reg. 200, the regulation that sets out the forms and procedural rules, is explicit. Amending a certificate of offense can only happen in a court hearing. And the Section 9 default review is not a court hearing. It is an in-office process. A justice sitting in chambers, reviewing paper. No defendant present, no Crown present, no hearing. So when a prosecutor argues, the JP should have just fixed the certificate, the answer is, the JP had no jurisdiction to fix anything. Rule 15 prohibits it. The Court of Appeal confirmed it. We'll show you that confirmation when we get to City of London versus Young. Not every imperfection kills a certificate. Courts distinguish between surplusage, harmless words that affect nothing, and substantive defects that go to the integrity of the document. Surplusage is the extra, adding of Ontario after the name of a statute when the statute already says Ontario. That doesn't change what you're charged with. That was R. v. Baldassare. Surplusage, not fatal. Substantive defects are different. A missing certification of service, an incorrect set fine, a missing informant name, a mismatch between the offense description and the section number. Those do affect the integrity of the document and your ability to understand what you're facing. Read that with me. The Provincial Offences Act strikes a balance between inferring from the failure of defendants to act, such that they are taken to have waived their right to be presumed innocent and their right to a hearing, thereby consenting to a conviction, while placing an overriding requirement on the justice, as the independent judicial officer put in place as a safeguard, the task of examining the charge document which has initiated the proceeding so as to prevent injustices from occurring. That's R. v. Cochael, 2001. Later approved by the Ontario Court of Appeal in City of London versus Young, 2008. That paragraph is the philosophical anchor of the entire default conviction standard. The JP is not a rubber stamp. The JP is a safeguard. And the way that safeguard does its job is by examining the certificate and quashing it if it is not complete and regular on its face. O-Reg 290, Regulation 200 to its friends, sets out the forms, the procedural rules, and the court administration framework for all POA proceedings. For charge-laying purposes, the forms are not optional decoration. They are part of the jurisdictional architecture. Get the form wrong, and the proceeding can fail. Quietly, without a fight. 5 forms you need to know. Form 1, the offense notice. Part 1. This is what gets served on you when an officer issues a ticket. It tells you what you're charged with, what the set fine is, and what your options are. Form 3, the summons under Part 1 requires you to appear in court. Used when an officer can't or doesn't issue a set fine notice on the spot. Form 4, the certificate of offense. Part 1. This is the document the officer files with the court. This is the document the JP reviews in Section 9. This is the document that has to be complete and regular on its face. Form 4 is the spine of the Part 1 prosecution. Form 2, the information. Part 3, sworn before a justice, the formal charging document for serious offenses. Form 6, the summons to defendant under Part 3, commands you to appear on the information. Now, Rule 15 of Regulation 200. Rule 15 specifies that 2 things can be dealt with only in a court hearing. 1, quashing a proceeding with limited exceptions. 2, amending an information, a certificate of offense, or a certificate of parking infraction. The Ontario Court of Appeal in City of London versus Young, 2008, relied directly on Rule 15 to confirm that a justice of the peace acting under Section 9 has no power to amend a defective certificate. The Section 9 default review is an in-office process. It is not a court hearing. The officer cannot ask the justice to just fix it. The Crown cannot ask the justice to amend. The justice has no jurisdiction to amend, not at the default stage. If you remember nothing else from this episode, remember that. In default proceedings, defective certificates cannot be amended. They can only be quashed. Section 21, subsection 2, the gatekeeper provision. What it does in plain language is exactly what it sounds like. It locks the gate between Part 1 and Part 3. Once an offense notice or summons has been served under Part 1, the Crown cannot simply file a Part 3 information and move on. They cannot upgrade. They cannot switch streams. They cannot quietly drop the Part 1 and start over with Part 3. They need a key. And that key is consent from the Attorney General or a properly authorized agent. Most prosecutors don't have that key. They think they do. They don't. 4 common reasons. 1. No set fine exists for the specific offense charged. Part Y needs a set fine. Without one, Part 1 isn't available. 2. Penalty exposure exceeds Part 1 limits. The Crown wants access to the larger penalties, or jail, that only Part 3 provides. 3. The officer simply chose the wrong stream at the side of the road, issued a Part 1 ticket when a sworn information was warranted. 4. A policy decision by the prosecution office that the public interest requires Part 3's process. The reason doesn't matter. The procedure to relay is identical in every case. AG consent, or a properly delegated agent, or it doesn't happen. Who can consent? The Attorney General personally, a Crown Attorney acting as a properly delegated agent of the AG, a person who has been specifically delegated consent authority by the AG. Who cannot consent? A provincial prosecutor on their own. They have authority to prosecute. They do not have authority to consent to relay. We'll see Jordan and Gray hit that wall in a few minutes. A police officer cannot consent. Anyone without documented delegation from the AG cannot consent. And this is from Saney, somebody named Wendy at the prosecutor's office. Last name unknown, no documented authority. That does not satisfy Section 21. This is where the Crown's most common argument falls apart. Section 6 of the Crown Attorneys Act says a provincial prosecutor conducts prosecutions delegated by the Crown Attorney. That sentence is about prosecuting authority, the day-to-day power to stand up in court and prosecute the file. Section 10 says every Crown Attorney and provincial prosecutor is the agent of the Attorney General for criminal code purposes. Read that line carefully. For criminal code purposes. Section 10 does not extend to the POA. Full stop. Criminal code only. Authority to prosecute, Section 6, and authority to consent, Section 21 of the POA, are distinct powers. A provincial prosecutor can stand up and prosecute a POA matter. They cannot consent to a relay from Part 1 to Part 3. That consent must come from the Attorney General or a properly delegated agent, typically a Crown Attorney. This distinction has sunk prosecutions repeatedly. A Part 3, information laid without the required consent under Section 21 is a nullity. The court has no jurisdiction to hear the matter. And here's why Section 25, that Part 3 curative provision we covered earlier, cannot save it. Section 25 addresses defects in the form of an information that the court otherwise has jurisdiction to hear. It cannot supply jurisdiction that never existed. The prosecution doesn't get a mulligan. They don't get to fix it. The matter dies on jurisdictional grounds. Quick limitation refresher before we get into the cases. Part 1, 30 days to file the certificate. Section 3 of the POA. Part 3, 6 months to lay the information. Section 76. Specific statutes can override. Compulsory Automobile Insurance Act gives 3 years. Securities Act gives 6. Always check the specific act creating the offense. All right, foundation laid, statute mapped, standard explained, forms cataloged, consent machinery understood. Now 8 cases, 2 streams, 1 consistent message. Procedure matters. 3 cases on consent, 3 different fact patterns, 1 consistent rule. R.V. Jordan, 1998. The foundational case. Facts. Original careless driving charge under Highway Traffic Act, Section 130 was laid under Part 1. The Part 1 was withdrawn. Then a Part 3 information was laid for the same offense. The defendant challenged jurisdiction under Section 21. The Crown made 3 arguments. 1, that there was a contractual right to authorize the relay. 2, that the Crown Attorney had given specific written authority. 3, that Section 10 of the Crown Attorneys Act made the provincial prosecutor an agent of the Attorney General. The court rejected all 3. Section 10 of the Crown Attorneys Act makes provincial prosecutors AG agents for criminal code purposes only, not the POA. Section 6 of the Crown Attorneys Act authorizes conducting prosecutions. It does not authorize consenting under Section 21. Only the Attorney General can delegate consent authority, and that delegation has to be documented. Jordan is the foundational authority on this rule, confirmed as good law 21 years later in R.V. Gray. The principle has not moved. R.V. Saney, 1996. Facts: a Part 1 offense notice was returned unserved. The officer went to the prosecutor's office, spoke to someone named Wendy, last name unknown. Wendy gave verbal permission to proceed under Part 3. No written consent on the information. The trial proceeded ex parte. There was also an identification problem. The defendant was identified at trial as Gurdeep Singh. The information named Gurdeep Singh. The court held, consent must be supported by evidence showing it came from a person with actual authority, with at least passing familiarity with the offense. The officer's belief that Wendy had authority was insufficient. Verbal permission from an unidentified person, even from someone with apparent or ostensible authority, was not enough. Without documentation, without evidence of actual delegation. Section 25 could not cure the defect because the court had no jurisdiction in the first place. Wendy is not AG consent. If you are facing a Part 3 information and the consent question comes up, the test is not, did someone at the prosecutor's office say it was okay? The test is there documented consent from the Attorney General or a properly delegated agent? R.V. Gray, 2019. Facts: the officer intended to lay a Part 3 information from the start, but data entry on the back end triggered a Part 1 instead. The Part 1 was eventually reopened and withdrawn. The Part 3 information was signed on October 3, 2017. At the time it was signed, the Part 1 was still technically active, and no AG consent had been obtained. The court held prosecutors have authority to prosecute under Section 6, but they do not have an automatic right to consent. Consent must come from the Attorney General or a properly authorized delegate, typically a Crown Attorney, and the consent must be clear at the time the Part 3 is signed, not generated after the fact, not reverse engineered to fix a problem. And here is the principle from Gray that the Crown does not advertise. The justice of the peace receiving a Part 30 information has a duty to inquire about prior Part 1 proceedings. The JP cannot just accept a Part 30 at face value if prior Part 1 proceedings may have existed. Jordan and Saney, 2 decades old at the time, were confirmed as good law in 2019. The line has not moved, and the duty to inquire principle gives defendants real leverage. If you are facing a Part 3 and there was a prior Part 1, the question, was AG consent properly obtained, is not just yours to raise. The JP has a duty to ask. 3 cases, 3 different facts. 1 conclusion: consent under Section 21 is not a formality, it is the door. 5 more cases, plus 2 we'll touch briefly, all on the Part 1 side, all on certificate defects fatal enough to quash convictions. R.V. Bertolucci, Wu and Young, 1995. Facts: HTA minor traffic charges across 4 defendants. The officer properly completed the certificates of offense, Form 4. The problem was on the other form. The offense notices, Form 1, served on the defendants did not include the officer's name. Justice of the Peace McCurdy quashed at first instance. The Crown appealed, arguing irregularities in form don't affect validity. The court rejected the Crown's argument. The informant's name is, quote, so basic, without it, the offense notice is a useless document for the purposes of the defendant. Failure to include it is not curable by particulars at trial. The principles of justice would not be served by permitting amendment of that basic element. Lesson: the officer's name on the offense notice is fundamental, not surplusage. If your offense notice, your Form 1, doesn't tell you who the informant is, that is Bertolucci. And the no amendment rule in default proceedings is even more absolute than what was at issue in Bertolucci, which was a trial case. R.V. Koschel, 2001. Facts: the defendant gave notice of intention to appear. Arranged for an agent. The agent failed to appear. That triggered Section 9.1, the failure to appear default conviction provision. The justice entered default conviction, but here is the problem. The certificate of offense contained no certification of service. The question on review, Did the defendant's own notice of intention to appear retroactively cure the defect? The court held, missing certification of service is fatal. The defendant's own notice does not retroactively cure a certificate deficiency. The POA strikes a balance, and you heard the full quote earlier, between the defendant's waiver through inaction and the justice's role as the independent safeguard. The JP is not a rubber stamp. If the certificate isn't complete on its face, the JP quashes. Coshail was approved by the Ontario Court of Appeal in City of London versus Young in 2008. It is foundational authority on the default conviction standard. R.V. DeAngelis, 1994. Quick one, but powerful. Facts: a pedestrian HTA offense. The certificate showed a set fine of $90. The maximum fine a pedestrian could legally be required to pay for the offense was $50. The only way for the defendant to resolve out of court, under sections 5 to 8, was to pay $90, already beyond what the law permitted. The court held a set fine exceeding the statutory maximum renders the certificate defective. The conviction was quashed. The ticket was incorrect on its face. DeAngelis was early authority on the set fine accuracy requirement. And as we're about to see, it became the template for the binding Court of Appeal decision in City of London 14 years later. City of London versus Young, 2008. Ontario Court of Appeal. Binding. Facts: 16 defendants charged under Part 1. The certificates had incorrect set fines. None of the defendants responded within 15 days. The matter went to J.P. Levitt under Section 9. J.P. Levitt quashed all 16 certificates under Section 9, not complete and regular on their face. The city sought a writ of mandamus requiring the J.P. to enter the convictions. The city made two arguments. 1, the set fine was surplusage. 2, the justice should have amended the certificates. The Court of Appeal rejected both arguments. Set fine is not surplusage. It is the information the defendant needs to decide whether to default. An incorrect set fine means the defendant was not given accurate information to make that decision. And on amendment, the Section 9 justice has no amendment power. Rule 15 of Regulation 200 confirms that the in-office review is not a court hearing. Amendment can only happen at a court hearing. This is the anchor case, binding on every Ontario court below the Court of Appeal. The decision expressly approved Coshail. If the Crown cites Billinger, which we'll get to in a second, to argue that minor defects don't void a certificate, remind them, City of London says set fine is not a minor defect. And Farah, also Court of Appeal, controls where there's tension between the two. R. V. Monahan, 2009. Facts: 8 defendants. The set fine boxes on the certificates were incorrect, but the total payable boxes, the bottom line including the victim fine surcharge and court costs, was correct. The Crown argued in effect no harm done. The defendant had the bottom line. The total payable was accurate. They had sufficient information to decide whether to default. The court was not having it. The set fine box must itself be accurate. It is a distinct figure. The court authorized penalty, separate from costs and the victim fine surcharge. A defendant might care about the set fine in isolation, maybe for insurance reporting, maybe for clarity about what the actual punishment is. Correct total payable does not save an incorrect set fine. Monahan closes a Crown argument that comes up repeatedly. Total was right, no harm. The court's answer: that argument was tried. City of London already disposed of it. The set fine box has independent significance. York versus Billinger, 2005. This one comes up in Crown submissions, and it deserves context. Facts: 6 defendants. The Crown applied for clarification on certificate regularity. The results were mixed. Billinger, kilometers per hour abbreviation issue, held regular. D'Agostino, sloppy 7 in a written number, held amendable. But D'Agostino had appeared. Trial stage, not default. Mowat, wrong or illegible section number, on a failed to respond default docket. Quashed. Serafraz and Cacciati, section number missing, but approved Regulation 200 wording was used. Held regular. The court drew the line. Where Regulation 200's approved wording is used, Absence of a section number alone does not void the certificate, but on a failed to respond default docket, a wrong or illegible section number destroys regularity. Strategic note for anyone facing the Crown citing Billinger: they will tell you minor defects don't void. Remind them, Moat was quashed. Same case, same year. Wrong section number on a fail to respond docket. Gone. And R.V. Farah, 2015, Ontario Court of Appeal 302, binding on every court below. Farah controls where there's tension with Billinger, which brings us to Farah. R.V. Farah, 2015, Ontario Court of Appeal, binding. Facts: 2 consolidated appeals, Farah and Mirza. Both involved a discrepancy between the short-form description of the offense on the certificate and the section number cited. In Mirza, the section number was struck out after service, and a new section number entered with the officer's initials. Neither defendant appeared. Default convictions entered under Sections 9 and 9.1. At the Ontario Court of Justice on Appeal, the court held the certificates were complete and regular. By the time it got to the Court of Appeal, the Crown had conceded the certificates were not regular. The Court of Appeal held a discrepancy between the short-form description and the section number cited on the certificate destroys regularity under Sections 9 and 9.1. Post-service alteration, even initialed by the officer, does not restore regularity. Because, and this is the line that anchors the whole framework, there is no amendment procedure in default proceedings, binding on all Ontario courts below. Where Billinger and Farah conflict, Farah governs 8 cases, 2 streams, 2 binding Court of Appeal authorities, City of London and Farah. 3 decades of Ontario POA jurisprudence, 1 consistent message. Procedure matters. Some defects are too fundamental to cure. Pull the 8 cases together and 6 principles emerge. Write these down. 1. Both streams have non-curable defects. Consent failures in Part 3, Jordan, Saney, Gray. Fundamental certificate defects in Part 1, Bertolucci, Kosciel, DeAngelis, City of London, Monahan. Neither stream is a procedural safe zone for the Crown. 2. The default conviction mechanism, convicting in the defendant's absence without a hearing, requires the certificate to be right. The exceptional nature of that power demands premium adherence to form. 3. No amendment power in default proceedings. Rule 15 of Regulation 200 is the regulatory anchor. The in-office default review is not a court hearing. The Crown does not get to fix the certificate after the fact. 4. Surplusage is harmless. Substantive errors are fatal. The dividing line is whether the error affects the integrity of the document and the defendant's ability to understand what they are facing. 5. Correct total payable does not save an incorrect set fine. The set fine box must be accurate on its own. Monahan. The bottom line was right argument was tried and rejected. City of London already established this. 6. Consent must be real, authorized, and documented. Verbal permission from an unidentified person fails. Saini. Authority to prosecute is not authority to consent. Jordan, Gray. And the justice of the peace receiving a Part 3 information has a duty to inquire about prior Part 1 proceedings. Those 6 principles are how the cases connect. Memorize them. They are what the framework actually is. The cases give you the law. The framework gives you the principles. Now add the checklists. These are starting points, not legal opinions. Every case turns on its own facts. Use these to identify the questions worth asking. Then find a licensed legal professional if you need advice on your specific situation. If you received a Part 1 offense notice or summons, go through this list. Was the certificate filed within 30 days of the offense? Section 3. Courts may extend, but you check. Does the offense notice correctly identify you? Name, address, driver's license number. Does the offense notice identify the informant? The officer's name. If it's missing, that's Bertolucci. Fundamental defect. Is the offense described with enough particularity that you know what you're charged with? Does a set fine actually exist for the offense charged? Check Ontario Regulation 950 or the applicable set fine schedule. Is the set fine amount accurate? Cross-reference the consolidated set fine schedule. Wrong amount is fatal in default. DeAngelis, City of London, Monaghan. Is the certification of service completed on the certificate? Missing certification of service is fatal. Koshael. Were you properly served with the notice or summons? Are the date, time, and location of the offense correct? Does the short form description match the section number cited? Mismatch destroys regularity. FARA, Binding Court of Appeal. Did the officer complete all required fields? Signature, badge number. Date. That is your Part 1 scan. If you are facing a Part 3 information, different checklist. Was the information sworn before a justice? Section 21. Was any Part Y offense notice or summons served for the same offense before the Part 3 was laid? This is the gate. If the answer is yes, you go to the next question. If yes, is there documented consent from the Attorney General or a properly delegated agent? Section 21. Check the information itself for a written consent stamp or endorsement. No stamp. Immediate question. Does the consent identify the person who gave it and their authority? Verbal is not enough. Saini. Was it a provincial prosecutor who purportedly gave consent? If so, that does not satisfy Section 21. Jordan, Gray. Was the information laid within the limitation period? Section 76 or the specific statute. Does the information correctly identify you? Are the particulars of the offense sufficient to understand what you're facing? That is your Part 3 scan. If you see any of these on a Part 3 information, flag it. No written consent stamp or endorsement on the information. Consent purportedly given by a provincial prosecutor, not a Crown attorney. Officer says consent was obtained verbally from somebody whose authority is unclear. No evidence of what information was provided to the consenting authority. Part 1 was active or had been served when the Part 3 was signed with no AG consent on record. Any one of those is a real question for the court. On the Part 1 side, red flags for certificate defects. Set fine looks unusual, too high, or doesn't match the schedule. Set fine exceeds the statutory maximum for the offense type. DeAngelis. Certification of service box not completed. Koshael. Officer's name, the informant, missing from the offense notice. Form 1, Bertolucci. Description and section number on the certificate don't match. FARA, Binding Court of Appeal. Wrong form used for the proceeding type. Certificate not filed within required timelines. If any of these appear on your paperwork, that is the question worth asking. So here is what you actually need to walk away with. 1. Ontario gives the Crown 2 streams to lay a charge against you. Part 1, the express lane. Part 3, the formal track. Which one you're on determines everything about your case. 2. Once a charge has been served under Part 1, the Crown cannot upgrade to Part 3 without consent of the Attorney General or a properly delegated agent. Most prosecutors don't have that authority. Most prosecutors think they do. They don't. 3. Convictions can happen in your absence, in chambers, on paper. But that mechanism operates under strict compliance rules. The certificate must be complete and regular on its face, and in default proceedings, the justice has no power to amend. None. 4. Some defects are too fundamental to cure. Missing informant name, missing certification of service, incorrect set fine, section number that doesn't match the offense description, consent failures. These are the kinds of errors that quash convictions. We made a handout for this episode. Every section we covered today, the statute citations, the comparison table, the 8 cases, the 6 principles, both checklists, and the red flags. All of it laid out in a clean printable PDF you can take with you. Free, no paywall, no account required. Go to youdefendyou.ca. That's youdefendyu.ca. Find episode 001 and download the handout, or just click the link below this video. If you are facing a charge, bring the handout to your situation. Walk it line by line, then talk to a licensed legal professional in your jurisdiction about what you find. This was episode 01 of You Defend You, laying the charges. Frank Alfano, LLB, University of London. LLM, Osgoode Hall Law School. 35 years in Ontario courtrooms. You may not be a lawyer, but you should never feel powerless. Clarity creates leverage. Preparation creates confidence. Understanding changes outcomes. I'll see you in the next one.